I know that. It's going up, it's just.
How deep is it?
It's us pond. I mean, it's fish. I mean, it's got plenty of fish.
Oh, no.
And then my sister-in-law has got a new working on fish, and he cleaned up around the pond, repaired his deck, and got it all in shape. So she went fishing this weekend several times.
All right. 24 CR 2109 is called the State of Texas versus Kong Van Pam. Mr. West is the attorney. Are you Kong Pam?
Yes.
Do you speak English, Mr. Pam? A little bit? A little bit. Ciao. And do you speak English and Vietnamese?
Yes, sir.
Fluently? Who are you?
I'm me.
You're his niece. What is your name, ma'am?
Good evening.
And how long have you been speaking English and Vietnamese in your life? Your whole life?
Yes, my whole life.
Okay. Raise your right hand. First of all, that's your left hand. God bless you.
He doesn't have a right hand.
Oh, he doesn't have a right hand. What happened? What happened? Was it in an accident?
Yes.
Sure about accident.
Oh, that's terrible. Okay, but raise your left hand and your right hand now. Do you solemnly swear or affirm that you will truly translate from Vietnamese to English, English to Vietnamese, Mr. Pam, Kong Pam's, and he's your father?
No, he's
Your uncle. Your uncle. His answers that he makes from Vietnamese into English, and the questions that are asked of him by the court or by his attorney, English, you will translate into Vietnamese, the language that Mr. Pam understands. You will do that correctly and accurately, so help you God.
yes, sir.
And I'm going to ask you to translate to Mr. Pam. I'm going to speak English, and I want you to speak Spanish. Spanish is what we often do.
Yeah.
Speak Vietnamese, translate Vietnamese. Are you Kong Pam?
Ông có là ông Công.
Yes.
You can put your hand down.
He said yes.
Okay. Do you solemnly raise your right hand, your left hand? Do you solemnly swear or affirm
Ông có hứa là nói sự thật
that you will make true answers to such questions as may be asked of you during this hearing,
và nói sự nói sự thật không?
and you will answer truthfully, so help you God?
Yes.
Lower your hand. And I'm going to ask him questions and just repeat, ma'am.
Yes, sir.
And tell us your full name. Tiffany Lee, do we have that? How do you spell Lee?
L.E.
Okay. Are you Kong Van Pam?
He said yes.
Okay. You won't say he said, just you'll answer yes on his behalf,
Okay.
just like he speaks.
Sorry.
Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Sean.
In summary, this indictment alleges that on or about April 10th, 2024, in Jefferson County, Texas, that you committed the offense of operating a motor vehicle while intoxicated. Do you understand what you're charged with?
Yes.
The indictment also goes on to state that you have 2 or more convictions of operating the motor vehicle in a public place while intoxicated. This states that you were convicted in 2005 and 2011.
Yes.
Do you understand? All right. If convicted of paragraphs 1 and 2 of the indictment, you are facing a third-degree felony, which means you can be sentenced to no less than 2 years in prison, no less than 2 years in prison, up to 10 years in prison, and fine up to $10,000. Do you understand?
Yeah.
An agreement has been reached, though, where you would be pleading guilty to what? The DWI?
Yes, sir.
Isn't that a class B?
No, it's
Class A?
enhanced.
A regular.
Or you know, regular?
That says lesser included. You know what? I've got Kim Wynn. This is Kong Wynn.
Yeah.
Kong Van Pat.
Kim, one we already did.
Yeah. Okay. That's,
Such a change up for me. I was like,
that was the only
No, I
Vietnamese
didn't.
name we had.
Yeah.
It's like, okay.
Sorry.
That's okay.
So
You were just checking us, weren't you, Judge? Thank you.
an agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended and you would be on probation for 10 years. You would pay $1,000. There would be terms and conditions of probation, which are normal and customary for this type of offense, for a DWI. And you must, as a condition of probation, you will be sentenced to 10 days. Is it 10 days?
Yes, sir.
You will be sentenced to 10 days in the county jail as a condition of probation. You have to go to jail for 10 days. Do you understand? He has to go to jail. It's required under Texas law for all cases of a DWI third.
A procedure coming from
Okay.
Yeah, we can do it later. I would request.
It can be postponed until he's able to do that. How long will he be unable to go to jail? When can he attend the 10 days, which is required?
protect the obstacle of his own. Can you take it in jail? No, nothing.
Yeah, you're allowed as long as you have a prescription.
Take it with you. Yeah.
Okay.
Yes.
Yeah, that's no problem. How long, when can you,
Good now.
a couple weeks, a week, 3 weeks?
No. Next week,
How about is 2 weeks good?
I can.
Okay, so he would check in. What's 2 weeks from today?
You can.
On or before 6
June
o'clock
9th.
PM.
June 9th.
Well, Tuesday, though, today.
Yeah, oh, that's right. That's right. Sorry.
Yeah, today's a Tuesday.
Would Monday be
Sorry.
better?
I'm living it like a Monday. I apologize.
Think we all are.
Monday
Is
is better?
Monday or in 2 weeks, Monday or Tuesday, which is better?
Huh? Tuesday.
Tuesday. All right. 2 weeks from today, you must check into the jail on or before 6 o'clock PM. And you would have to spend 10 days and then you'll be released. If I follow this agreement, you have no right of appeal of your case.
Say yes.
How do you plead to this charge, guilty or not guilty?
phải you say guilty.
Are you pleading guilty voluntarily and because you are guilty?
Wow. Yeah.
And prior convictions of DWIs in 2008, 2005 and 2011,
Yeah.
are those true and correct as they are alleged in the indictment?
Yes.
And are you pleading true and correct voluntarily because they are true?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that?
Yes.
Did you understand it, discuss it with your attorney? Are the contents all true and correct in State's Exhibit 1?
Yes.
State's Exhibit 1 is made a part of the record for all purposes without objection?
Okay.
Okay. This states that you are mentally competent to enter your guilty plea, and it is freely and voluntarily made. You understand what you're charged with. Your attorney has reviewed all of this with you.
Yes.
You are guilty of the offense charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true and correct, this says. Is that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes, without objection.
No, yes.
Is a pre-sentence report waived?
Please, Your Honor, yes.
I'm going to follow this agreement. And Mr. Palm, I'm going to find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
Yes.
You are giving up your rights to a jury trial and the rights to the presentation of witnesses. You are satisfied with your attorney, and you are also guilty of the two DWI convictions in 2005 and 2011, as the indictment shows.
Yes.
And all of this is true and correct, so help you God.
Yes.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is waived?
Yes.
All right. I'm going to find you were pleading guilty to paragraphs 1 and 2 of this indictment, which constitute a third-degree felony.
Ở trong hồ sơ là vì tội phạm.
You are mentally competent to enter these pleas today. State's Exhibit 1, admitted at this hearing, supports your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of DWI. I am going to follow this agreement. You are hereby sentenced to confinement in the institutional division prison for 10 years. That is suspended and you were placed on probation instead for 10 years.
And
Please follow these terms and conditions of probation that the probation officer is going to review with you here in a minute. You must pay a fine of $1,000. You must stand. You must have an auto ignition interlock system in any vehicle you operate. That's to test you before you start the car to make sure you're not intoxicated. Everyone with a DWI has to have that. There will be other terms and conditions of probation that the probation officer will review with you. Please make sure you follow these terms. If you fail to follow these terms and conditions of probation, your probation could be revoked. And then you could be sentenced up to 10 years in prison. We don't want that. So make sure you're always sober when you drive. The probation papers are given to this lady. Please speak with her and she will go over all those terms and you're going to need to translate with her and Mr. Palm.
Yes.
Mr. Palm, do you understand what has happened today, sir?
He's on his medication. If he gets in, how do we?
Yeah, he has to have a prescription. Okay, he needs to bring that when he checks into the jail.
Okay. Prescription having medication.
And what they'll do is they'll keep it and they administer it to him. They have to give it to him because they don't want, if people kept it in the jail, they'd give it to other people. We don't want that. It's in the bottle. He has to bring that with the prescription. God bless you.
The prescription is he's going Houston, Winston, Texas.
Get them to send an email with a prescription or something and print it out, something to verify that it's prescription.
Yeah, work with Mr. West. He's the attorney. If you'll tell him where the prescription is, they can fax or send something to him and he can print it out properly. And if there's a problem, let me know.
Yeah.
Okay, he needs to report
By next 2 weeks from
June
today.
10th.
Yes.
June 10th. That's okay.
When you check in the jail, in
The jail, yes.
Jefferson County, yes, ma'am. Here, please see the probation officer. Thank you. Thank you. Ciao. Right to talk to him and to get heard and find out what his plan is on representing your family. Yeah.
Your Honor, I tried to speak with him and he told me he didn't care and that I get to go do something. We tried to speak to him 3 weeks since he was appointed to him. He would not answer his phone. He would not return calls. He would not return messages.
All right.
Not
What's
from anyone,
what's
sir.
the defendant's name? Again, your son's name?
Zane Buren.
Okay. I'm going to set that for a hearing tomorrow morning.
I don't know if I can.
Okay, we live in Austin, Texas. I drove
I'm
at
sorry.
4 a.m. to be here.
Yeah,
We were gonna
see, he's gone. What I wanted to do is set it for tomorrow, have Mr. Dusler in here explain why he's acting that way. If that's the way he's acting now, I'm hearing your version. I want to hear him too.
Yes,
But he's supposed to handle, all the defendants are supposed to be represented by competent, vigorous representation.
and he told me outside he didn't care, sir. And that's where his words.
Well, I'd like to, I need to,
Is there
to talk to him
was
about
standing there when I was trying to talk to him? Oh, he would, he didn't hear,
Yeah.
he was saying he was outside.
Well, I mean, don't call witnesses if you
Sorry,
don't know what they're
no,
saying.
sir, I'm sorry, I just thought, no, he was standing there, I apologize. But Your Honor, I can attest to my son has been staying out of prison.
Okay, but the scientific test proves otherwise. We've been doing this 19 years, sir. and
It's been less than 40 days, sir, since he was arrested, and I promise you, sir, he's been doing everything to stay out of the way. Enrolled in school, in
You're
college.
saying that the marijuana has been in his system for 40 days?
Sir, he's.
Is that what you're saying?
Yes, sir. I would like
Sorry,
I would-
it's not going to work.
Sir,
It doesn't. That's not
marijuana
the way
can
it
last up
works.
to hair and hair follicles 90 days, up to 60 days in your urine if you're a chronic user.
Anything else?
No, sir.
Okay. We're going to give you Mr. Dusler's number. I want to know if he's recusing. There's a posted note right there. If
have
he
it
is
here.
not, if he does not answer phone calls in regards to immediate family members who are trying to
Yes,
get information for their client, that would be inappropriate. And I'll have,
yes, sir. I'm sorry.
and then he's appointed at the court's discretion. And if lawyers are not treating clients and relatives of clients, especially those who are in custody appropriately and professionally, then I'll deal with it firmly.
Your Honor.
And that I don't put up with that. And I don't generally get complaints.
And I
But
would,
when it does, we get to we address them. You have a right to find out as much information as you can about your
agree,
child.
Your Honor, but Your Honor, I promise you, my son, I wouldn't be standing here if it wasn't for the fact that he was doing so well in life. I would not be standing here, Bridget. Okay,
Yeah.
and
Well, look, just at the end of the day, not to say that you're
still
don't act,
3,000.
don't act naive. But let me just tell you, when people use drugs, I've only been doing this for 40 years, involved as a defense attorney,
Yeah.
a prosecutor, a judge now for 19 years.
Yes, sir.
When it comes to drugs, people are rarely forthright
Yes, sir.
because it's something they know is wrong and they hide it, and it gets the best of them, and they lose their abilities to really think rationally because they become the drug overpowers them, and it's always been that way.
Always, yes, sir.
And
Long as
I see it over and over again.
My brother
And
died of
the
drug
family
overdose.
members are the last one. They're never going to do things in front of their family or let their family know because they know it's wrong. They're ashamed of it, but they're stuck. And I'm thinking when we deal with this, we have a 92% success rate in our probation, especially drug cases.
Yes,
The average is 75% in the country.
yes.
We have a 92 because we deal with things pretty aggressively on getting help, especially with drugs.
Yes, sir.
But I know what you're saying,
He has,
but
he
I
doesn't
know-
use
I
any
don't-
other drugs.
but I know what happens over and over
Yes,
again
sir.
for 40 years, sir.
Yes, sir.
40 years.
I have no
It's-
doubt in my
The
mind.
parents come up here and they're shocked and ashamed and they're trying to defend their child, but he's a grown up
Yes, sir.
and you don't see him all the time. And you don't see him all the time, and they're not going to use drugs in front of you. They're
No,
not going to
sir,
run embarrassed.
Yes, sir. I wouldn't, I understand what you're saying. Yes, sir.
But
Again,
the
he doesn't
scientific
use-
test is what we use, and that is
Your Honor, if
is,
you were to give him a
proven.
chance, I can guarantee you, he comes back in for 30 days, he will not have anything in his
it's in the
system.
debate.
That would give
I don't
plenty
deal
of time
with,
for his system to be clean of marijuana.
I can't deal with, I'm not going to deal with you on that. He tested positive, and that's what we test for. Now, his lawyer needs to get in the game to get him up here so we can resolve this case one way or the other.
So that's when I had asked him outside. I asked him if he would come in and try to talk to you. He goes, no, this isn't Austin. And I said, sir, you're here to represent my son. He said,
That's,
do you live in Austin? And he brought up Austin again. I said, sir, I live here as a child. I know what
I
you see."
understand. And he
And then
shouldn't,
he walked off on me. And I
Well-
said, sir, can you please go let them know he hasn't been out?
Are you-
long enough?"
but you're not going to be able to be here tomorrow?
No, sir. I missed up. I own a tattoo studio, and
Okay.
he's got school in the morning and work tomorrow.
I'm sorry. I can get him back in the morning and talk to the attorney and have him explain, but you're not going to be here. And have him explain what you have told me. And without you being here,
Yeah.
it's not going to be much of a debate.
Yes, sir.
But I can bring your son back and ask or direct him, since I appointed him
That
as
would be
the attorney,
amazing, sir.
direct him to aggressively deal with this case, and also be forthright with family members, close family members, so they are not in the dark on the way he's going to represent your son.
Yes, sir. And I can show you numerous calls that we've made to his office, both of us, over the past 2 weeks. No answer, no reply to messages, very thorough messages, very clear. Made sure we just need to get some information about court. We were trying to appear by Zoom today because we live so far and he
Yes,
has
sir.
work.
Oh,
And we thought that would be better, but, Your Honor, I
But
promise
see,
you,
that's,
if
see,
he
that's
wasn't
another problem.
working so hard.
This is
to
why
stay
I
away
don't
from
do,
here,
see, this is also why we rarely do Zoom, is because when it's dealing with drug cases, we don't have the ability to test.
Sure,
And
yes, sir.
I can guarantee every drug defendant would want to appear by Zoom, and we're not able to test, which is what we have
And
to.
Your Honor, we didn't get a reply. We drove our butts up here. I got up
Good.
at four o'clock this morning after I worked till midnight. I slept an
I
hour.
caught in a storm, huh?
I drove through it, Your Honor.
Yeah, yeah, it was a
drove
bad
through it.
storm.
He's not a flight risk. He's not going anywhere, and he's not a doper. He smokes in the hot, man. And I,
That's not right,
no,
but that's not
no,
right.
it's not.
And you
It's
don't
not
even-
right.
And here's the
he's
deal,
done-
you don't
he's
even know
done.
what unless you're making it, you don't know what's in it anymore.
Right. It's
I mean,
dangerous.
I had people here with synthetic marijuana cases.
It's so
which
bad.
is-
And you know,
which is-
there's a lot of
like-
legislature going on, so there's a lot of that stuff, THC going on in Austin right now. And I totally understand it's illegal, period. But Your Honor, I promise you, it's been a small amount of time. And with the amount of weed that these guys smoke every day, all day, I know that he's doing the right thing, Your Honor. If he wasn't, I wouldn't be standing here.
No.
He's doing better than he's ever done. His mother's been in prison for murder since he was 4.
So
It wasn't worth. His mother's been in prison for murder since he was 4. Out of this, Jennifer Walter. Yeah,
in
that's
this court?
I don't know who it was Halloween night of 1999. Jennifer Walter and Christopher.
Yeah, that's before I got there.
Yeah. It was me. I was 19 years old when I had him. It was me. And that was it. And I didn't have any parental guidance. I'm lucky to be standing here in front of you myself, sir. I'm
Why is that? Because you've learned to make the right choices.
because I didn't make I didn't make good choices, and I didn't have anybody to help me make good choices. But he has somebody here now, and although I wasn't doing the best when I was younger, as past 14 years have been phenomenal. I own 2 businesses. I also help with an entertainment company, and I'm staying out the way. And I've worked. I would not. A year and a half ago, I would not be standing here talking to you. I wouldn't be here.
What I do when you test positive, you heard,
Yes, sir.
bond is revoked,
Yes,
then
sir.
it's double. Plus you have to wear a drug patch.
Yeah,
And
and
that's
I can't
all
afford
the-
double the bond. I
Yeah.
spent everything I had just to get him
What
out. and
I'll
I
do
would
is
only-
I'm going to list, I'll bring it back tomorrow. Whatever the bond may be, I can change a bond.
Yes,
for
sir. I'm
any-
poor.
But a drug patch is going to be required.
Yes, Your Honor, if he comes back in here and he's dirty, lock him up and don't give him a bond. I don't care.
But
I
he
promise
can't,
you, he's
we
doing
don't
good.
release him until he tests negative.
Okay, yeah, it will
And
probably
then
take
he's gonna have
about
to have a
30
drug
days.
patch, because if you put a drug patch on early, it'll test positive.
Yeah, right. Yeah, yes, sir.
When they
And
take
I don't
it off.
want that for him.
Yeah,
man.
and
I
he's-
just don't
he's
want him to get
involved.
kicked out of school.
So we'll bring him back tomorrow.
Yeah.
Then I'll do a drug test on him and see what happens tomorrow.
Okay, yeah,
And then-
it's just for marijuana, and that stuff binds to the
No.
fats. It's not like it's out of your system in 72 days. If you do the research, it binds to the fat cells in your
Thank
system.
you.
30 to 60
I'm
days.
familiar with it,
Yes,
sir.
up to 90 in the hair.
But too often marijuana is used
Yes,
as a
sir.
carrier with other methods. And
He just had,
also you don't know what's in how some marijuana is stronger than others. And It just works that way and it works differently. And that's why when you sniff it, if you smell it, you run like the wind,
Mhm.
especially if you're on bond. You don't even want to sniff it.
Yes,
You
sir.
want to move out of the way, stay out of the way.
Oh, and that's almost.
Because you don't know
impossible
what
out
it's
there.
going to take to get into your system. And the tests are those are profoundly accurate tests is what has been proven accurate for decisions and science. So that's why we don't do it flippantly.
If it had been over 2 months, I would definitely not even have asked you anything about that or even attempted to. I just thought his attorney should have said, Your Honor, sir, he has only been out of jail for 40 days. He hasn't had enough time to get his system cleaned out. Give him a couple of weeks to get his system cleaned out. Come back, take a test.
We'll bring him back tomorrow and
Yes,
see
sir.
where he is.
Yes, sir.
And then I'll bring him back every few days until it tests negative.
Okay. And that's fair. And when he
That's
says
what we-
negative, sir, I promise you,
And I'll talk to Mr. Dusler about what your complaints are, but
I'll try again, Your Honor,
Yes,
to
sir.
contact him. And even on his Google reviews, it says he does not contact us. Because I tried to make sure I was calling the right thing. And on the reviews, it says he will not communicate with his client. And it's several reviews if you look yourself. And that's the thing.
I don't.
I was scared when I walked out there and he was representing my kid because he didn't even sit here and say, oh, no, sir, he's this,
Okay.
you know. That was the first thing he should have said was that he has only been out for
Yes, sir.
40 days.
Okay. All right.
Well, I really appreciate
Thank you,
you
sir.
taking the time to
You
listen.
have you have the defendant's name for tomorrow
Yeah.
on this case? Thanks.
Can I get back to
Tom.
You should let the bridge.
And we now call 18-28851.
Hey, Tom.
Kim Wynn, that's you, sir?
Yes.
And Thomas Wynn is your attorney. Are you related to Mr. Wynn? Wynn is like a Smith, isn't it? Language. All right.
Giles, Mr. Giles, what you had was a.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, we can, Your Honor.
In summary, Mr. Wynn, in 18-28851, you were charged with the state jail felony of engaging in organized criminal activity. And the indictment goes on to state that on or about January 4th, 2018, my God, I was just a teenager back then. Why did this take so long? Did you move or something?
Yeah.
Joe, are you still living at 11814 Sharpview?
Yes.
Okay, in Houston? Something must have happened, because that's, we're talking 7 years.
It's a long time ago.
Long time ago. It looks like you were at 17814 Sharpview at one time. Then it's 11814 Sharpview is where we have you now.
I never been to the other one, maybe.
You never been at 17814 Sharpview?
No.
Never lived there? That's what happened. That's what the indictment shows. But you're at 11814
Yes.
now. Okay.
Somebody transpose a number from 7.
Yeah, the one number off.
Yes, sir.
Which in Houston, that's everything.
Yes.
3 million people. All right. Again, on or about January 4th, 2018 in Jefferson County, Texas, you committed the state jail felony of engaging in organized criminal activity by intentionally and knowingly operating and participating in the earnings of a gambling place. And which involves 8-liner matters.
Yes, sir. We're pleading to the lesser included of gambling promotion, which is on that second paragraph on the next page. Part of the offense the offense of
Well,
gambling.
this is,
promotion.
I've never seen an indictment written like this with what appears to be 3 different paragraphs. So each of these paragraphs constitute a separate offense.
No, sir. They're all one offense is the part of the
Second and
engagement.
third,
Yes, sir.
second or third.
Yes, sir.
Either one is good, right? It doesn't require second and third.
Well, no, they both say and, so it's part of it's not or, it's an and, so it's all one crime. It's just the way they alleged it. But we're proceeding under the lesser included of gambling promotion, which is the last part of that last paragraph. Make it a class A misdemeanor.
Yes. Yeah, he does.
Gambling's in 47. It's 702 is gambling, so in 47.
First disposition of gambling paraphernalia ban.
You look at that.
It's in Code of Criminal Procedure. All right.
Yes, sir. And I think forfeiture have already been filed on all of these, so I think that's already been taken care of. This is dealing with was one of the employees that was working there. It was not a manager or anything.
So section 71.02 Texas Penal Code, among other things, states that a person commits an offense with intent to establish and maintain or participate in a combination or in profits of a combination or as a member of a criminal street gang or foreign terrorist organization, which is inapplicable here. The person commits or conspires to commit one or more of the following. And subpart 2, any gambling offense punishable as a class A misdemeanor.
Yes, sir.
So, you go to gambling under chapter 47.02, a person commits an offensive
We're doing
make the
gambling
bet,
promotion.
make the bet, plays and bets. And that is no, that is a class C misdemeanor. What we're looking for is what it takes for a class A misdemeanor.
Gambling promotion is the one we're.
47.03.
Yes, sir.
That is a class A misdemeanor. Operates, participates in the earnings of a gambling place, engages in bookmaking, or game, becomes a custodian, sells chances, or gains, sets up the moat. Okay.
Yes, sir.
So all of those are different ways you can commit.
Yes, sir. The last paragraph, last sentence talks about committing offense of gambling promotion or keeping a gambling place. We're going gambling promotion because he did participate in the proceeds.
Okay, that is all under 47.02. That's what he's going to be, the lesser included offense.
Yes, sir.
Is what he's gonna
Gambling
be.
promotion, yes, sir. 4703.
So we're taking organized criminal activity out and then
4703. Gambling
section
promotion.
47.03, a person commits an offense if he intentionally or knowingly operates or participates in the earnings of a gambling place.
Yes, sir. Yes, sir.
And this states
The last
that
paragraph,
he
it
did
states
then
that
and there.
if you look at the last paragraph on the last page, that top part, it says participated in the proceeds of.
Right here in the first paragraph, it says, did then and there intentionally and knowingly operate and participate in the earnings of a gambling
Yes, sir.
place.
Okay.
So it appears that it is clearly a lesser offense that can be applied, which is a class A misdemeanor,
Class A.
carries with it up to 1 year in the county jail and a fine up to $4,000 and or a fine up to $4,000. Do you understand what you were charged with here in this case, a state jail felony, but what is agreed upon between the lawyers that you would be pleading to the lesser included class A misdemeanor? It's bad. We won't ever use it again.
It's very touchy.
It doesn't show up until about 3 seconds after you write. And then, so you can't
We only do it 10 seconds.
write
So right
much.
after I wrote it. Nothing bad was enough.
God bless you. Class A, you would be pleading guilty to the class A misdemeanor of gambling promotion and be placed on 1 year deferred or unadjudicated probation. Is that 500?
Yes, sir.
Fine. Okay, I got it. It turned out to a 3. It's not 3, it's 5.
It's 500.
Redo it, 5. And placed, on 1 year deferred or unadjudicated probation for this class A misdemeanor, $500 fine. There would be other terms and conditions of probation which are normal and customary for this type of crime. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included class A misdemeanor under the state jail felony? Guilty or not guilty?
Mute.
Are you pleading guilty voluntarily and because you are guilty?
Mute.
Yes.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Did you understand it? Discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence and without objection
No objection now.
admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses like you were pleading guilty to now. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true of state, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I'm going to follow this agreement and find, sir, you are pleading guilty today voluntarily to this Class A misdemeanor of gambling promotion. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am not going to do that. I'm going to defer any finding of guilt for 1 year, place you on deferred or unadjudicated probation. You must follow certain terms and conditions of probation. There will be a fine of $500, which must be paid, and the probation officer will go over those terms. If you do well within 1 year, this case will be dismissed. Do you understand?
Yes, Your Honor.
If you fail, your probation could be revoked, and you could be sentenced up to 1 year in the county jail. We don't want that. So please see the probation officer and do well. Thank you. Yes, sir. Thank you. Super and steward as well. What are we here for?
Do you have one?
It says other here.
It's a judge, or I guess others, the other different. So we're waiting on a case involving a determination of whether he is lawfully required to register as a sex offender out of the Austin District Court that we filed. And we've got cross motions for summary judgment going on in that case.
What do you want to do today?
And then we just need to reset it.
How much time?
We need 8 weeks at least.
All right.
It's 2,000 days old, just so you're aware.
Well,
When I reset.
Well, I
want you
know,
to
but
get back. Okay.
Sorry, we're following the process that the legislature is making us follow. Instead of letting him determine whether or not it's a lawful determination, they require a district court in Austin. So it's not
Yeah.
nothing we can.
There's going to be 8 weeks, but if we find out sooner, let us know. Or if we don't find out, let us know so we can get this moved.
We understand. Thank you, Judge.
It was a blood draw.
Yes, Your Honor, it was 0.133.
What else? Anything else?
No, just alcohol, Your Honor.
Because there was marijuana in the car.
Yes, we only tested it for alcohol. The DPS, the way that it works is if they test over 0.08 for alcohol, we do not test
They
it for
just
drugs.
drop it.
Yes.
All right. You're still at 10333 Clay Road?
Sir.
Where do you live, sir?
431 Orange Avenue.
431.
Orange Avenue, Port Arthur, Texas.
There's an Orange Avenue in Port Arthur.
Yes.
That's 77640, right? What's his zip over there?
77640.
Are you employed somewhere? Oh, is Langston Adams your attorney?
Well, no, I'm on initial designation, initial designation. I think,
Are you,
Another indigent.
are you retained?
no, sir.
Oh, okay.
No, sir.
Are you working somewhere?
Yes.
Where?
Bethel, I just, been off work for a week. I was sick. I would like to ask, request to give him a paid lawyer. If that's fine.
Who have you talked to?
Jay Hona out in Houston.
Oh, okay. So where are you working though?
Bethel,
Like, how much do you make an hour there?
30.
You're gonna hire your own lawyer.
Yes, sir.
Yeah. Yeah. That's how much time do you need to do that?
Weeks. 2 weeks.
Two?
2 weeks, yes, sir.
You got three. Three. You got three.
Yes, thank you.
Oh.
Yeah.
Do you understand you're charged with the state jail felony of operating a motor vehicle while intoxicated with a child under 15 years of age? If it would have just been DWI, it wouldn't have been a felony. But because there's a child involved in the vehicle who is at risk, it's a state jail felony, which carries with it up to 2 years in the state jail. Do you understand? Mr. Adams is going to continue to represent you until you can get somebody hired. If you need to get some advice, you call him. He's standing by if it's needed. But it sounds like you got a plan, so.
Great.
That's what we'll do. We'll set it with 3 weeks. Get a resetting and also just have a seat in there in the box before you leave. We're gonna test you to make sure that there's no alcohol or drugs. Okay. Are you Derek Robinson?
Yes, sir.
Are you still at 10776 Gage Road?
Yes, sir.
Beaumont? You're charged here with the state jail felony of illegal possession of synthetic marijuana. And that carries with it up to 2 years in the state jail. Are you retained?
I'm appointed on it.
No. Okay. Where do you work when you're not hauling drugs around?
I'm just currently getting out, so I'm not working here. Just currently getting out. I did 7 years. And
Wait, 7 years in prison?
yes, sir.
How long have you been out?
Like about 2 months left.
And you get arrested for drugs?
No, it's old.
This was actually, it looks like from 2018, Your Honor.
It is 6 years old. They just never did anything because you've been in prison?
Yes, sir.
What were you in prison for again?
Family violence.
For 7 years for family violence?
7 years.
That's not the way it works. I do this every day. You just don't get it from family violence. You must have been charged with aggravated assault. Is it from Jefferson County?
Yes, sir.
You don't get 7 years. How many convictions do you have? Do you have other convictions? Did they stack them together?
No, it was enhancement.
And what do you mean? Enhancement?
It was enhancement. It was
Because of a prior conviction?
yes.
Okay, so you had a conviction before a felony conviction, which made you weren't allowed to get probation from a jury.
Yes.
What was your conviction for before?
It was for family violence.
For family violence. Oh, and then you get charged with another family violence charge? Were you on probation at the time?
For the first one, yes, sir.
For the first one, and then you committed another one while you were on probation?
Yes, sir. And
Was it in this court?
and they enhanced it.
Oh, that's what I do. But print that out so I can see it, please. So what's your status of work? You're not working?
No, I'm currently looking.
And Judge, I think I can move this case today.
Yeah. Here's something that's got to be moved today, and that is he did not fill out. There's no indigent form here that needs to be filled out before we dispose of the case.
Yeah, I don't have no motion. It's not supposed to. So just put that on the phone. No, we try to move it today.
Look at this. Sign, it's initialed by the JP, but nothing's filled in, and then it's. You want me to tell in front of everybody?
No.
You look at it. You gotta fill that part out. It looks like somebody initialed for the justice of the peace without it being filled out, which is improper.
Yes, sir.
You just can't make this stuff up, like night court. All right, it needs to be filled out.
All right, we'll try.
No, this, I'm trying to take it.
This, I'm trying to pick it right now, today.
Back in February, so we got March, April, May, 3 months have gone by. Back in February, you were arraigned in front of the magistrate for this second-degree felony of assault on a peace officer, which also includes 2 prior convictions, 2016 robbery. And you were convicted in the court next door, the 252nd, also in the court next door. After that was final, you committed unlawful possession of a firearm by a felon and were convicted of that in 2019. Thereafter, it is alleged you've committed this offense. I'm looking at this affidavit of indigence. And this was, you were in front of a magistrate 3 months ago. And do you remember what you told the magistrate? You're going to hire your own lawyer. That's why he didn't appoint us. I know you didn't hire him. Who'd you hire? So are you lying to people? 3 months have gone by. You were supposed to hire somebody 3 months.
Yes, sir. I had to first finish paying off my bond, sir.
You don't have a plan in mind about how you're going to do things? You've made a promise to the magistrate that you didn't keep. Thanks for wasting all of our time and the people's time and money. So who are you going to hire now? You've had more than enough time. Who are you going to hire?
I need some more time.
No, you don't. You're not going to get it. We're not waiting on you. We're moving forward. You're an habitual felon. According to this, you're looking at a minimum of 25 years in prison, minimum to life. You know what that's going to cost? Do you?
No, sir.
Who have you talked to in 90 days?
Sir.
Who have you talked to? What attorneys have you talked to? No one. That's why we don't wait on you. We're moving forward. The whole idea is to trick people, mislead, deceive, whether it's a judge or anyone else. Stall, stall, stall. Maybe it'll go away. No. You got our devoted attention. You have got my attention. And that's not what you want. Sit over there. Sit over there. We're going to deal with you and the other people who are taking care of their business. We can take care of them. Thomas Skinner. Come on out, 25 CR.19. That's you, sir?
Yes, sir.
Okay, what's your address? Is it still 365?
No, I had moved to Austin.
Everybody's moved. What is it now?
412 East William Cannon.
What?
412 East William Cannon.
East William Cannon.
Austin, Texas, yes, sir. East William Cannon.
What is the zip?
I believe 787.
Yeah, speak up.
I believe 78745.
How long have you lived there?
For the past year.
For the past year and you don't know your zip code?
I never use it last time.
You never use it?
No, sir.
It comes in handy when you write a letter.
I haven't wrote a letter in a long time.
Or paid a bill.
Sir?
You pay bills, don't you?
I pay the person that's owns the stuff.
Oh, you're renting there?
Yeah, I'm just.
Oh, okay. All right. Did you get your driver's license changed?
No, sir. I haven't had a chance to be able to get my.
How long have you been there?
I'm just doing my obligation.
A year? That's no excuse. That's not, the state doesn't put up with that. What do you have, 60 days? 60 days, something like that. That's all, days, not a year.
Boy,
You don't have a driver's license?
No, sir.
Well, how do you get around? Do you walk?
My dad brought me here.
Okay. But you don't operate a motor vehicle? But you still have to have a state ID of some sort.
I haven't been over to get my ID.
Who's the landlord there?
His name is Space Savers.
Okay. Friend, acquaintance. All right. Now, let's get to the meat, the guts of this one. You're charged with what's called engaging in organized criminal activity, which in summary, you and others collaborated in, according to the grand jury, in carrying on a criminal activity which involved illegal possession of a controlled substance and possession of dangerous drugs and illegal possession of marijuana. You understand what you're charged with? And this, the way this has been indicted, this is a first-degree felony if convicted. You're facing life in prison if convicted. Do you understand?
Yes, sir.
But what happened was the way the probable cause affidavit is, you all had a large-scale drug operation going on Homer Drive in Beaumont, and people convicted of such a thing talking about pounds of drugs, they end up paying a steep price. All right.
For roughly 4 weeks, it's a brand new case. Yeah,
You're unable to hire a lawyer? Is that right?
I'm trying to obtain.
Are you able to, where are you working right now?
Right, I work at a recording studio, and I'm also a student.
How much do you make an hour?
12 every,
You know,
12.
yeah, that's like 20 grand. But for a first degree felony, an attorney's going to cost that.
Right.
At least. Fill out an indigent form. Get over there, fill that out, an indigent form, and that's to be completed so Mr. Dusler can continue to represent you. You can hire somebody anytime you wish. The taxpayers would love that. Rather than paying for your mess, we would rather have you earn it and pay for messes. But until then, fill that out. On the other hand, you're not. You got drugs in your system. You got you tested positive for tetrahydrocannabinol marijuana. Your bond is revoked. What is his bond?
30,000, Judge.
Is revoked. It is now doubled to $30,000. Yeah, you can blame yourself, not anybody else. You got to have I'm going to speak and you be quiet. Thank you. This isn't a debate. The test shows you've got drugs in your system. All right. And stand by. Yeah. You shouldn't be surprised. I mean, you're in organized criminal activity of making drugs. Anyway. Your bond is now $30,000. Plus, you have to have a drug patch as a condition of bonds. So, if you post a bond, once any drug gets into your system, I'll know about it, and then you won't have a bond the next time. This one out. Mr. Dusler, you're his attorney. Yes, sir. All right. He's going to be taken into custody. What's the next event?
An announcement, Judge.
An announcement in 4 weeks. That is all. You got to be kidding me, right?
What's that?
That's what you wear?
I didn't have any clean shirts. Mostly clean.
You don't have a clean shirt at all? I'm on the Salvation Army board. We got all kind of stuff for people, but you can't wear. I mean, would you wear that to church?
No.
Why not? Disrespectful? Would you say it was disrespectful for church? Well, you don't think court
I do apologize.
you don't think the Constitution is something that deserves respect?
I apologize.
You got to do better than that.
I understand.
There's no excuse in this town. I mean, we're low.
Well, I live in Hampshire. Still just.
You will, but we take care of people from Hampshire too. We can take care of people.
I do
We can't.
apologize.
Yeah, I don't want to see that again.
Okay. Hope you'll never see me again.
Look, everybody, yeah. You know, if I had $1 every time somebody said that, I hope that's true, but I'd be Donald Trump. If I had $1 for every time people said that. That just seems to be what everybody says, but I see him a few months later in court over and over again. Anyway, and fix this. Have you ever been convicted of a felony before?
Yes.
What?
Another engagement.
Is that it?
Yes, I believe so.
You don't know?
I'm sure there's one more. I can't remember what.
You
I was
forgot a
convicted
felony
one.
conviction? You
I
forgot?
was on probation for 5 years. in 2010 for child endangerment, child abandonment.
Okay, was that regular probation or deferred?
It was deferred.
Okay, did you get revoked?
No.
Okay, you weren't convicted.
Okay.
You don't know that?
I was assuming I was.
Who said, how would, well, you look into that. I don't think you're convicted if you were on deferred and it was not revoked,
Okay.
sir.
I'll look into that when I get out.
Is there anything else that you can't remember that you coming back to your mind?
That's all I can remember.
All right. I think if you would have had that prior conviction, what county was that?
Jefferson.
It would have showed up on the indictment.
Okay.
And it's not.
Okay.
Well, you don't want to go around filling out job applications saying you were convicted if you want to. So you're not going to get a job.
Yeah.
Huh?
It was.
See, it was deferred and it's been dismissed.
You're welcome.
Okay, you're clear,
Okay.
except for this now.
Yes, sir.
See back over there.
All right. It's a state jail felony which carries with it up to 2 years in the state jail. All right. Does the defendant who's here with his attorney, Mr. Deucer, waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about February 28, 2025 in Jefferson County, Texas, you committed a state jail felony of theft, which carries with it, if convicted, confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine up to $10,000 can be assessed. Do you understand what you're charged with?
Yes, sir.
Anyways, probation.
Do you understand what you're charged with here and
Yes,
the
sir.
punishment range applicable?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on deferred again,
Yes, Your Honor.
where you're $1,504.
Okay.
How soon could you pay that back?
I can pay. I don't have a job right now, but I have a girlfriend and she's helping me out. But I'm going today and trying to find a job. Same 6 months.
But don't be bumming off your girlfriend, off your.
Well, I don't. I mean, I do try and find odd jobs.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty, sir?
Guilty.
Are you pleading guilty voluntarily?
Yes.
That is on your own free will
Yes.
and because you are guilty.
Yes, Your Honor.
I'm going to show you what's marked as State's Exhibit 1. That thing. That all of our pads are down except that one. The one we don't ever use, and we don't want to ever use, but we're stuck using it now.
Yes.
You can see why. It's an odd thing. You've seen State's Exhibit 1. Did you sign it voluntarily, understand it, discuss it with your attorney, or the contents all proved correct?
Yeah.
State's Exhibit 1 tendered into evidence without objection. Among other things, it states you were mentally competent to enter your plea of
Yes,
guilty.
sir.
It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to your jury trial and your rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer.
Yes, sir.
All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence reports waived.
Yes.
I'm going to follow this agreement. And I'm going to find you pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to place you on, you know what it is, deferred or unadjudicated probation. There will be terms and conditions of probation that you need to follow so that you are not revoked and convicted.
Yes, sir.
The first thing, you will pay restitution in the amount of $1,504 to the complainant, the victim. That must be done within 6 months.
Yes, sir.
There will be other terms and conditions of probation which are normal and customary that the probation officer will go with over with you in a minute. Make sure you follow those. If you fail, your probation can be revoked.
Yes, Your Honor. Thank you.
You're then be found guilty and then sentenced up to 2 years in the state jail.
Thank you, Your Honor.
You're gonna go over all of those.
Is it a relevant issue?
It's how long?
You do well, it can be shortened to a third.
Thank you.
Okay. Do you see that, ladies?
It's all filled out.
30830 is now called the state of Texas versus Derek Robinson. That's you.
He's the case that he had for 7 years. So we're gonna move it today.
You're here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment in 18-30830 alleges that on or about April 20th, 2018 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance. Do you understand what you're charged with here? Illegal synthetic marijuana. If convicted, you face confinement in the state jail for any term of not less than 180 days or more than 2 years. In addition, the fine may be assessed not to exceed $10,000. Do you understand? Yes. We're going to take out the pad and use a different stylus. An agreement's been reached where you would be sentenced to
Put 7 months.
7 months. Is that right?
That's correct, Your Honor.
It's not my case, Judge. I was just standing here.
You're just standing here.
Yes, sir.
Yes, sir.
7 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of the state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty? Voluntarily and because you're guilty.
Yes, sir.
Okay. Good luck. Here. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence?
No
And
objection.
without objection, it's submitted. Among other things, the state should be mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1, part of the record purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement if nothing further and finds you, Mr. Robinson, you are pleading to the state jail felony of illegal possession of a controlled substance voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt. I am following this agreement, and you were hereby sentenced to confinement in the state jail for a term of 7 months. You will be given credit for all time you have served. You understand what has happened today, sir?
Yes, sir.
All right. We'll begin sentence immediately. How much time do you have credit, do you know?
You should have time served, Your Honor. I believe it's showing 211 days.
So if you got enough time, they're going to check you in and then you go out.
No, it's going to take a couple of business days. We do have to send paperwork.
Well, no, this is actually, I made sure it was at the jail here. The time he said in there on the jail here.
We still, because he sent it to state jail, we still have to send a teletype to state jail. So it
Okay,
may
right.
take a couple of business days.
Okay.
It may not. I can't.
Hopefully.
I'll do my paperwork today, but it depends on other entities, how long it takes for them to do their paperwork. So
No, I don't think no.
But they'll be able to see at the jail later.
Very difficult. I mean, you're taken into custody. That's just the way it is.
Yeah.
Okay. What else?
That's it.
yes, sir. right, here's this.
And I got Robinson Police. Something more Robinson.
You're Javon Joseph?
Yes, Senator.
Two cases, 24 CR 1398 and 1399. A state jail felony of attempting to take a weapon from a police officer. Lucky you weren't killed. And a second degree felony of assault on a peace officer in 1399. So state jail felony carries with it up to 2 years in state jail. And the other case, second degree felony, you can be sentenced up to 20 years in prison for that case. What are we doing today?
Judge, on this case, she's 19 years old. I did get discovery from Mr. Ham. I did get an officer swimming. I applied for the free trial diversion program. She was denied. But what I want to do today is just take one more shot at asking for reconsideration. And the reason being is she's 19 years old. And I know Mr. Ham is aware that I did apply for the free trial diversion, and they did reject her. I mean, I got a rejection letter from. So where I am right now is just asking for reconsideration. That's what I am
about
today.
19. She's an adult.
Mr. Knaut's not going to approve somebody with this type of offense, Judge.
Yes. Yeah.
So I'm just asking to reconsider.
But she's an adult. Like most people here, they're adults. Once you're adult, you're held accountable to being an adult and to knowing better. You're not a child. And you're held to responsibilities after an adult. That's what's normal. Okay, she's 19, so then 20, 21, 20, where's the cutoff? Where you're too old? You're too young. There isn't. That's why we set it at 18. 17, yeah. Most people have rights and privileges at 17. Anyway,
Well, Judge, I just want one more.
I understand.
And that's it. Just one announcement.
4 weeks.
That'll work.
You got it. Thanks. Okay. You're charged with third degree felony, was also engaging in organized criminal activity, namely burglaries, thefts, and credit card abuse, a little of everything. Don't ever show up in this courtroom with that shirt or anything like that. Just look around. Just look around. There's a tie. There's a tie. There's a man with a shirt, but just that's not appropriate. Would you wear that to church? Why not? Because it's disrespectful. So you don't think much of court. This is about the Constitution of the United States, what we do in here, which is something to be honored and respected. You got to act like it. I can guarantee you wear that in front of a jury would find it offensive and wouldn't give you the time of day. You got to do better if you can. What are you asking for?
Some time there on this is, there's some issues regarding the underlying obligations here. So we got about 3 weeks to be great.
3 weeks.
Resetting and I'll look outside.
Resetting.
I think that is all to have this morning.
You do the thing. Yeah.
You're McConnell Williams and David Grove is your attorney. Have you met him before?
I'm the expert.
Yes, sir. I believe we met once before.
He doesn't remember you.
I believe, Judge, we got ready for a plea in this case.
You don't remember?
Not plea.
This is my first court appearance.
I'm talking about meeting with him though outside of court.
No.
Well, we gotta. So go on here.
I could for about 5 minutes. I don't have a telephone number.
It's an initial appearance at Stace, but you had been here April 9th and it was reset until today. So maybe something on April 9th and it says Mr. Grove is the attorney.
April 9th, I wasn't here. I haven't had a court. This was my first court appearance. I never ever received paper.
It may have been reset before the knowledge.
It says, the resetting says, due to weather situation. So I believe that probably may have been what happened, Judge. It was 4 weeks of hearings,
Oh, yeah, no, we could have done those today.
So it shows Mr. Grove was on your case as of February. Then, oh, here's what happened. Then there was a bond forfeiture.
Yes, sir.
Okay, you didn't appear. So you have a $50,000 bond plus a GPF.
They had got it recalled.
They did?
Yeah, the bond, I took them, I never received my paperwork from it, it's transfer bond. Yeah,
So what is your bond now? You
I
know,
made it.
25,000?
It was 25,000.
Okay. Say, where are you working?
Well, right now, I'm at Florida, like this.
How did you pay $25,000 bond?
That was last year, I was working there. You know,
Where were you working at?
I was driving trucks for a company.
Okay, you say 4 weeks?
Yes, sir.
All right, we're done. Get a resetting 4 weeks. Please. Thank you.
Yes, sir. Please. No,
Yvonne Gilbert?
Yes. Yes, sir.
Two cases.